I will again say thank you, Mr. Chairman, and members of the committee. My name is Jeff Shafer. I am the director of the Hale Institute at New St. Andrews, and I am of counsel with the Langdon Law Firm. I've been in the practice of law for approximately 25 years, the better part of which has been focused on constitutional law and litigation. I had the privilege of filing an amicus brief with the Supreme Court last summer in the Dobbs case on behalf of several hundred state legislators from 41 states, among whose number were several in this chamber. So it's a privilege now to address you. I've reviewed what I understand to be the written submission from Professor McLeod and share his conclusion that the holding and reasoning of Obergefell do not bear upon the provisions of this bill that declare marriage in its natural common law contours and allow for recording of marriages. And it's this point that I'd like to elaborate and emphasize. Obergefell's innovation was in disqualifying the husband-wife model as the standard for state licensure of civil marriage. The court in Obergefell was not faced with and did not rule on the status of common law marriage, nor does Obergefell otherwise require or authorize the idea that states need abandon the common law recognition that the husband-wife union represents a pre-political reality and is unique and central to the pre-existing family order that state domestic relations law thereafter approaches and reinforces. Further, the court in Obergefell did not rule against the venerable legal principle that kinship bonds between a child and his mother and father are of primal human significance and call for the law's deference and protection, as these bonds together represent the family relationship of a normative type. That is to say, Obergefell did not purport to eliminate a state's prerogative to continue to acknowledge in its legal standards the natural family. And since the natural family may be given unique treatment relative to other relational types, there is no impediment to state law recognizing the historic institution marking out the unique procreative union that grounds the family. The common law recognition of natural marriage preserves and represents in law the weighty distinction between a child's relation to the male-female union responsible for his or her existence and identity, and a child's non-relation to, for instance, a same-sex couple whose partnership is categorically irrelevant to procreation and offspring. State policy may continue to acknowledge and honor the deep human meaning revealed in the originative and perpetual ties of mother and father to child, ties inscribed in the very physical constitution and visible identity of that child. Nevertheless, prominent legal scholars and advocates have proposed that Obergefell's same-sex redefinition of civil marriage licensing standards requires state law to treat all partner types as equivalent in all respects, even relating to children. This, of course, requires, as these scholars both recognize and promote, the elimination of biology and gender as considerations governing the decisions as to whom the law will anoint and license as parents. And with that elimination, a child's law-ratified parents need not be from coupled relationships and need not be limited to two persons. Thereby are blood ties nullified and replaced by the custodial wishes of state decision-makers and the unrelated adults to whom children would be distributed. This is the repudiation of family as we have known it, and indeed proposes a reimagining of human nature itself. Procedurally, states are under no obligation to accept such implications of family law upheaval and contradiction simply because of Obergefell's redefinition. The Supreme Court in Obergefell gave precisely no consideration to the millennia-honored legal unanimities of human meaning present in genealogical connections, or to the court's own jurisprudence honoring blood ties, or to our historic domestic relations traditions rooted in the primordial and irrepressibly intuitive truths of sexual complementarity, natural generativity, motherhood, fatherhood, and ancestry. State recognition of the natural family is not unconstitutional, nor is state recognition of the unique relationship that founds it, that is, the procreative union of man and woman, of husband and wife, marked out in institutional form by common law marriage.